Excellent. Thank you everyone for joining our fifth Advocacy Institute session of 2020. We launched this in 2020 and we're thrilled that so many of you have enjoyed it. So this is our fifth session. It is going to be employment rights for people living with a disability. October is National Disability Employment Awareness Month. So we couldn't think of a better topic for this month than chatting about your rights if you're living with disability in the workplace. First, we'd like to thank all the MDA advocates who submitted questions ahead of time. Many of your questions were going to be used in this presentation. So for those who did, thank you very, very much. We really appreciate that. And before I begin, I just wanted to do a quick plug of our advocacy program. Many of you are probably part of the advocacy program since you found this webinar. But if you aren't part of our advocacy program, we would love to have you. We'd love to get you on our list so you can see the latest actions you can take on Capitol Hill in your community or hear about events like this. So if you want to join, please go to mda.org/advocacy, or you can actually text in MDA USA to 50457. Again, that's MDA USA to 50457. You can see that instructions on your screen. So we would absolutely love to have you. So today's agenda, we're going to talk about this topic in four parts. One is the history of non-discrimination laws. Then we'll go into your rights today, what you can do if you encounter an issue, and then we'll give a legislative update about what's going on in Capitol Hill around this issue. We're thrilled to be joined by three experts today to help us guide us through this presentation. The first is Neal McNamara. He is a partner at Nixon Peabody, and he's a member of the Labor Employment Group, where he represents companies, organizations, and individuals and counsels them regarding employment issues. We're also thrilled to have Hillary Baca with us. She is also at Nixon Peabody and a part of the Labor Employment Group. And she has experience representing employees in both federal and state court and administrative agencies. She also advises both employees and employers on complex employment and traditional labor matters. So we think we're in great hands today for this topic. And then we're also joined by Brittany Hernandez. She's the Senior Director of Policy and Advocacy here at MDA. And I'm your moderator. I'm Mark Fisher. I'm the Advocacy Engagement Manager here at MDA. So we're just thrilled to have you. And let's get going with our first question, which is about the history of non-discrimination law. So Neal and Hillary, I'll turn this to you. What is the history of employment non-discrimination laws for those living with disability? And before you answer, if you'd like to introduce yourself further, please go ahead. So I'll turn it over to you.
Well, thanks, Mark. I think I'll start off on this because I did a little research on the history and have some personal knowledge, and I am older than the rest of you, so I remember things that you don't know about. So I think in terms of what led to the non-discrimination laws with those living with a disability, I think, from what I've read, we can start the story with Special Olympics, which was founded by Eunice Kennedy Shriver, a sister of John and Robert Kennedy, in the 60s. And I believe that her motivation for that was of her many siblings, also including Teddy, they had a sister, Rosemary, who was developmentally disabled. So I think that was the Kennedy family motivation. And to this day, the Shriver family, so the children of Eunice Shriver are very much involved. So that, I think, brought the issue of the disabled to the nation's consciousness more than it had been previously. After that, sort of in the late 60s, there were some statutes. For example, I found the Architectural Barriers Act, which barred barriers in federal buildings, and then the Urban Mass Transit Act, which required that wheelchair lifts be installed in new mass transit vehicles. That was in 1970. The Architectural Barriers Act was in 68. Then in 73, a very important act was passed, the Rehabilitation Act of 1973, which prohibited discrimination in federal programs and services. Following that, at about that time, and one of the things that may have spurred the passage of the Rehabilitation Act was a scandal in New York involving an institution for the disabled called Willowbrook. that had been, I think, established in the 50s and was revealed by someone whose name you may know, Geraldo Rivera, who was a local TV reporter in New York at the time. And I grew up in New York, so I remember when this happened. And it was revealed that Willowbrook was essentially a hellhole. It was a storage place for people with disabilities. They lived in filth. There were experiments done on them. And on a personal note, I will tell you that I had a cousin who was developmentally disabled who died at Willowbrook in the 60s. So when I learned about it, and I was a child in this, so I didn't really understand what was going on. But so I think Willowbrook had a lot to do with the Rehab Act. Then after the Rehab Act in '73, there was the Individuals with Disabilities in Education Act, which is the act, another very important act, which requires that a free and appropriate public education in the least restrictive environment be afforded to any child with a disability. And again, on a personal note, I have a child with a disability, Down syndrome, so I'm very familiar with what goes on pursuant to that act. Then there was the Air Carriers Access Act, which provided for equal access to air transport in '88. The Fair Housing Amendments, which expanded the rights afforded under the Fair Housing Act of '68 to those living with a disability. And then, of course, the Americans with Disabilities Act in 1991. I think part of what led to this also was, again, an outcoming of what happened at Willowbrook was the independent living movement, which had led to the closing of a lot of those institutions and moving to more group homes and less store housing of people with disabilities. So then in terms of the Americans with Disabilities Act, Hillary, do you want to go into the act a little bit?
Sure, I'm happy to. Hopefully everyone can hear me all right. The Americans with Disabilities Act is something that I deal with probably almost every day, and it protects people with disabilities from unlawful discrimination and retaliation in the workplace. And so I spend about half my time at Nixon Peabody defending employers in these types of cases, and the other half the time I spend advising them on how not to run afoul of the ADA. And I think the biggest piece, and I think we'll get into it more in later slides, but I think that the most important piece for a lot of people is the interactive process and the duty to accommodate, which kick in under the ADA. And so what that means is when someone with a disability needs assistance or a modification to their job duties or their work environment to perform their role, as long as it's reasonable and not an undue burden to the employer needs to provide that accommodation to the individual. And they have to figure out kind of what these accommodations are and what can be done and what can't be done, and kind of what'll be the best fit for the employee and the employer. The parties engage in something called the interactive process, which is basically you sit down and the employee talks about, any limitations they have or any accommodations that they need, and the employer says, okay, we can do X, Y, and Z. Does that work? And you have a back and forth basically. And for whatever reason, this trips up, I think, a lot of employees and employers, and a lot of parties on both sides, even today, are not clear on, their obligations or, what steps they actually have to take. I think a lot of times parties aren't clear on, whose responsibility is it? Does the employee need to come forward and say, hey, I have a disability, I need help? Or is it on the employer to notice that something's going on and that maybe they should step in and begin the interactive process? So all of these fun issues arise under the ADA, and it's definitely what I spend probably half my time on disability discrimination advice work and case law, trying to help employers and employees on the other side kind of figure out what to do and what their rights are under this law.
Great. Thank you both for that. I'll just say that we recently did an institute on the ADA and the recent anniversary of it. So if you're interested in that, please check that out on our website. We did a whole webinar about the ADA. So that's a great segue there. So thank you both for that history. I did not know all of that for sure. So I really appreciate you going into that. It's very fascinating and kind of what led to the laws that many of us rely on today. So our next topic would be, what are your rights? Let's kind of just get down to it. So our next question is, what are your rights when both applying but also interviewing for a job? What rights do you have during those processes? I'll throw it over to Neal or Hillary.
Neal, do you want to jump in or you want me to start?
Why don't you start and I'll jump in.
Okay, sounds good. So you have the same rights when you're applying and interviewing as you would as an employee under laws like the ADA. California has its own fun version, and a bunch of other states do as well. So in California, we have the Fair Employment and Housing Act, which provides for a lot of the same rights that the ADA does, and other states will have their similar versions of it. And so basically what this means is that when you're applying and interviewing for a job, an employer is not allowed to, assume that you have a disability or take note of a disability that you have that's maybe apparent to them, and discriminate against you based on that. They're not allowed to make their hiring decision based on whether or not you actually have a disability or whether they think you have a disability. And so you are protected when you're kind of applying and interviewing for a job. I think that said, there are a lot of unconscious biases, and I think for those people who have a disability that's more apparent or more obvious, I still think a lot of employees can face, or applicants can face, hurdles when they're interviewing for a job, even if it's not blatant or kind of in your face discrimination or different treatment in the application process. I still think it's something that can happen a lot, unfortunately. But there are protections for you under the law, and there are ways that you can kind of try to vindicate your rights if you feel like you've been not given a job because of your disability.
Right. So what, obviously everything Hillary said I agree with. What an employer can ask you, either in an interview or on a job application, is whether you are able to perform the essential functions of the position with or without a reasonable accommodation. And that's as far as they can go. If you say no, that you need an accommodation, then we go into what Hillary has already described as the interactive process to determine what accommodations are available, whether they're sufficient to allow you to perform the essential functions of the job, and whether providing those accommodations would involve imposing an undue hardship on the employer or not. And determination of what is a reasonable accommodation and what is an undue hardship, a lot of it depends on the employer in terms of the size of the employer. So, for example, if you're applying to a small company with 25 or 50 employees, and you would be the only person performing this function, then it may be, depending on the level of the accommodation required, it may or may not be an undue hardship for the employer to provide that. On the other end of the scale, if you're working for CVS or Walmart, and there are many, many people who perform the same function you do, then that really puts the onus much more on the employer to justify why they cannot provide a reasonable accommodation. And I apologize for the piano playing in the background, but that's my son with Down syndrome in the living room. So it's a little serenade.
Oh no, I like it. No problem.
I was just going to say, we rarely get serenaded on our advocacy institutes, Neal. So
well,
welcome.
they just include my house all the time, and you will have James, and he will just serenade away.
I like it. Thank you both for that. I know we talked about this was mentioned before, Hillary, I think you mentioned it, but does someone have to disclose they have a disability, whether in the interview process or when they're on the job? Do they even have to, or how does that work?
No, you don't have to disclose the disability unless it interferes with your ability to perform the essential functions of the job. So I think Hillary raised an interesting point about whether a disability is apparent or not, and what that can lead to in terms of the biases of the employer, in terms of what their perception of your abilities are based on the whatever disability you may have, without, and they may perceive you as having a disability that disqualifies you from performing the functions of the job, when in fact you don't have such a disability. You may have a disability, but it would not interfere with your ability to do the job. So I think your obligation to disclose that you have a disability only occurs when that disability prevents you from performing the essential functions of the job and you require an accommodation. So, and also Hillary raised the issue of, do you have to request the accommodation yourself, or should the employer, if they notice something, bring it forth? I always discourage clients from inquiring about these things, but depending on the circumstances, it may not be inappropriate for an employer who sees that an employee is facing challenges in performing their job. That may be appropriate for them to inquire in a very diplomatic way. But generally, I think it should be the employee should recognize if they need help or accommodation, and approach the employer with that.
Excellent. I wonder if you could clarify, I promised I wasn't going to throw questions at you, but I think this is a good one to ask. When the employer asks if you can complete the essential functions of a job, is that with or without accommodations?
Both. So it's, can you do it with accommodation or without? So if you say I can do it without accommodation, fine. If you say I can do it with accommodation and identify the range of accommodations, you should. But the phrase is with or without a reasonable accommodation. Because if you can do it with a reasonable accommodation, then you can perform the essential functions of the job. It's not an issue, or shouldn't be an issue.
Great, thank you very much. I know we talked about accommodations, so let's just go right into it. What accommodations must an employer provide? I know we talked about reasonable accommodations, but I don't know if we can go into that a little bit.
So the only limit is really kind of your imagination and your doctor's imagination and what's reasonable, basically. There have been all sorts of accommodations that have come up in case law or that I've seen in practice in real life. And it just very much depends on the type of accommodation for the specific individual and what their needs are. But I mean, it can range from making physical changes to a workplace. So for example, a basic one that a lot of employers will do is installing ramps or modifying restrooms to accommodate for walkers or wheelchairs or things like that. It could include, modifying the layout of a workplace potentially. I think a lot of employers that I've worked with are starting to make use of accessible and assistive technologies. So ensuring that the software on their computer is accessible. I've had employers who've provided screen reader software, things like that, using video phones if they have employees who are participating in conference calls who are hard of hearing. There's employers that have, made materials available in Braille or done large print postings. I've had some that have done sign language interpreters or closed captioning at meetings. And whether every employer is going to be able to do this kind of goes back to what Neal said, right? If it's a small shop of 5 people, hiring a sign language interpreter for one employee might not be something that's reasonable. It might pose an undue hardship for them because they are small. and it's a huge cost. But for a larger employer, that might be a cost that they're willing to bear, and that they have to bear legally. Other accommodations, service animals is a big one. So allowing people to bring their service animals into the workplace when normally pets and animals wouldn't be allowed. I think the biggest one that I see and that gets employers into the most trouble is medical leaves. So if someone needs to take time off from work to, I don't know, attend doctor's appointments or attend therapy or whatever it is, but they're going to need, a significant amount of time away from work to care for their disability or to address it or whatever it is. A lot of employers will say, okay, well, you have, your 12 weeks under the FMLA, and then after that you can come back, or that's it, you're fired. And under the law, that's not it, right? So additional medical leave beyond what's provided by the FMLA and the state equivalents can be a reasonable accommodation. There's tons and tons of case law on this. So medical leave is probably the most common reasonable accommodation that I deal with, at least on a daily basis.
I agree with that, Hillary, and I have, as I'm sure you have also, clients who call me and say, well, and actually it's 13 weeks in Rhode Island, but 12 weeks in most places, is the 13 weeks is up, can I fire them? I was like, no, you can't fire them. And again, depending on the size of the employer, I always advise them, we need to give them some additional leave. But if it gets to the point, and I have actually a couple of cases right now where I think the one case that I'm thinking about, the employer had provided an additional 8 or 10 weeks leave. And when questioning, like, when can you come back? And this was an employer with only 12 employees, so they had been quite generous. And I was counseling them through the whole thing and, sort of holding them back. But when it got to the point where the employee went to her doctor once more and simply extended, her, to her next appointment, which was another month, at that point I said, all right, there's a bunch of case law out there that says that indefinite leave is not a reasonable accommodation. So the employer can, if they are bumping up against a significant period of time beyond the FMLA that they have provided you, and you still can't give them a firm date, that is something to just keep in mind, that it may cause you a problem. Another thing I wanted to bring up is that I had a case a couple of years ago where this woman in a manufacturing facility, the employer wanted the employees to be able to cross-train and work in several different areas so that, when people were on break or on vacation, they could, without, disadvantaging the operations, move people around, and they were all sort of well-versed in the duties and responsibilities. Well, this one woman said, I can do 3 of the 4, but I don't want to work in that 4th one. And even her psychiatrist wasn't able to articulate particularly why the conditions in that area were so different that she could work in 3 of them, but not in this 4th one. And again, the employer was very generous. It went for many, many weeks beyond the FMLA. Well, actually, it didn't involve the FMLA. She just walked out, but they didn't fire her for until 3 months later. And then the principle there is that the accommodation cannot be one that essentially rewrites the job description. So the job description is very important, and of course, the job description has to reflect reality. If the job description does not reflect the actual job duties, then that's too bad for the employer. But if the job description, is an accurate representation of the duties and responsibilities, and what the employee is looking for is to rewrite a significant portion of that, then that can be a problem for them as well.
Excellent. Thank you so much for that. So let's go on, just because we have lots of questions to get through, and there's a few coming in, but let's get to the ones that that our advocates sent in early. So we actually got a few questions that came in about this top one, and some of them are pretty specific based on issues, but I thought in general, let's kind of answer it in general. What can you do if you feel like your employer is not making a reasonable accommodation? What steps can someone take?
So there's a whole host of things that you can do. I mean, I think the first thing to do would be to escalate it internally, right? So if you've gone to your manager, your supervisor, and you've told them that you need an accommodation and you'd like to engage in the interactive process, and you don't need to use those words necessarily, but you've made your intent clear, and they've, poo-pooed you or said that they can't do it or just go back to work, or you're not getting anywhere, not getting any traction. I think that probably the best first step is to escalate it, right? So go to that person's supervisor, or ideally go to human resources. Some smaller companies may not have a dedicated HR, but if you're at a mid-sized to a larger company, they should have someone that you can talk to. And that's, a human resources professional, this is kind of their bread and butter. They do this a lot. They should know the basic rules. They should know what they can and can't do. And as soon as you kind of tell someone in human resources that you need some type of accommodation, their ears should prick up, and they should kind of jump into action and begin engaging with you on the issue. And hopefully that'll resolve the situation, that once you raise it with HR, that you'll, they'll work with you and you'll have your needs met. If you don't have HR, or you're still not getting traction internally at a company, and you've kind of gone up the chain and made requests of different people, you can always, some companies have hotlines that you can dial into, and you can always make a report to your federal or state administrative agency and get them involved. So in California, we have the Department of Fair Employment and Housing, and it works closely with the federal equivalent, the Equal Employment Opportunity Commission. And both of these agencies, and I'm sure the state agencies in other states, have websites where you can go and fill out a form and lodge a complaint and say that you need help or that you'd want them to investigate the situation. So that's an option as well. I think they both also have hotlines and all sorts of resources. And I've actually had friends of mine who've had issues getting accommodated at their smaller employers, and they went online to the EEOC's website and printed a bunch of stuff and brought it into their employer, and then all of a sudden the employer was very cooperative. So I don't know, Neal, do you have other ideas?
Yeah, we just want to add, I can understand why an employee who has an issue might be reluctant to go to an investigative agency in fear of being retaliated against. But I wanted to reassure everyone that the law prohibits retaliation if you engage in what we call protected activity. And certainly recruiting the assistance or seeking information from your local Human Rights Commission. I mean, in Rhode Island, it's the Rhode Island Commission for Human Rights, and Massachusetts, the Massachusetts Commission Against Discrimination, or the EEOC. You are legally protected from retaliation. So with that knowledge, hopefully that will make it easier for you to pursue those avenues so that you don't sort of suffer in silence.
Those are great suggestions. Thank you. Obviously, at some times that's not enough, obviously, because there's a whole profession around this. So obviously sometimes it might escalate to something that someone might need legal assistance for help. So how would someone find legal assistance for an employment issue or dispute pertaining to a disability or not getting an accommodation someone might need?
I think a first line of inquiry would be to the local bar association. So every state has a bar association, and also, in larger states, there would be county bar associations. So I know in New York, each county in New York City has its own bar association. In Rhode Island, there's a Rhode Island Bar Association, and you can contact them and they can direct you to people who may be able to help. Then, of course, there's, you could just go in and search on the internet and see if there's anybody in your area. Unfortunately, the quality of some particularly private practitioners who are solo in this area is less than optimal, should I say, and may not serve your interests ultimately. But unless you have a friend or associate or relative who is a lawyer and might be able to, send you in the right direction or give you any ideas, I think those are the best. And Hillary, if you have anything in addition, I welcome hearing it.
Yeah, I think the Bar Association is usually what I tell people, or if you're involved in some kind of public interest group or organization, sometimes they will have connections or referrals.
Right.
But yeah, no, I think the Bar is probably the best option.
Well, and I should have mentioned this already. I was, for many years, on the board of the Rhode Island Disability Law Center. So and while they had limited resources and weren't always able to help people with employment issues, there were knowledgeable people on staff who would go out of their way to try to direct you. So, and every state has, it's called, I think it's public assistance, public advocacy, something or other. But there's a nationwide system, and every state has a disability advocacy law group that you can find without too much difficulty, I would think. So that, again, that's another resource that would be specifically keyed into this issue of disability law.
Those are great tips. And I think this last question might be a little related. So if it is, that's fine. But how would you find an attorney that specializes in employment issues like both of you specialize in? Is there such thing as an ADA certified attorney? You might have answered it with that last part, Neal, but I figured I'd pose it again.
I'm not aware of any certification for ADA attorneys. Hillary, are you?
I'm not either, no.
Yeah. So again, I think you're not going to find sort of a certified list of people who have received some sort of qualification or certificate in employment law. So you just need to follow those research avenues that both Hillary and I mentioned to try to seek one out. And always remember that if you feel uncomfortable with the first person you talk to, don't settle. Keep looking. There's always more lawyers out there.
Excellent. Thank you both for that. That's really great. It's really great advice. I think we just wanted to shift now to our last topic, which is kind of legislatively what's happening on the Hill that could help with this issue. So with that, I'll turn it over to Brittany.
Thank you. And before I get into this, I just want to, thank everybody for joining and just clarify that while we are thrilled to have two really accomplished and well-qualified attorneys on this call, that nothing should be construed as legal advice. And so please keep that in mind. So MDA is pleased to have endorsed and support a piece of legislation called the Disability Employment Incentive Act. This bill is sponsored in the Senate by Senator Bob Casey and Senator Tammy Duckworth. And what it would do is increase incentives for employers to hire and retain people with disabilities as employees. So some of the things that it does is creates tax credits for hiring an individual living with a disability. It would increase existing tax credits to help employers retrofit workplaces for both employees and clients with disabilities. Things to, like perhaps building ramps or including more technological innovations and things like that to ensure that their workplace and or storefront is accessible to as many people as possible. And this is the legislation has been introduced in both the House and the Senate, and we are encouraging all of our advocates to take action on it. You can easily email your members of Congress about it by visiting mda.org/advocacy and going up to the tab that says Action Center, and send an email to your members about it. And when you do, hopefully you'll get a response back from them thanking you for your interest and saying that they would be pleased to sign on as co-sponsors. So the more people that we can get sending out this message to Congress, the better. So please join us and help us promote these kind of incentives to ensure that more individuals with disabilities can be hired and work in the workplace.
Great. Thanks, Brittany. Again, before we wrap up, I do think there's something came in that I think that would be an easy question to answer, which is, are bathrooms considered in those accommodations? A few people wrote into us about accessible bathrooms, and I didn't know if only of you could help answer that question, if that applies to employers or not.
It applies to places of public accommodation, and certainly an employer would be that. Because any place that brings in people from the outside would be a place of public accommodation. So yes, and I've dealt a little bit with Title III of the ADA, which deals with building accessibility issues, so that would apply both to employers. It would apply to like doctors' offices, any number of places of public accommodation. It's obviously a very broad definition.
Great. Thank you very. Oh, go ahead, Brittany.
Yeah, and I was just going to say, Mark, to clarify the question around whether or not there is such a thing as an ADA certified attorney, that is not something that exists. So if you do come across an attorney who says that they are ADA certified, you maybe want to take a little bit closer look at them in their practice.
Well, to be blunt, Brittany, they're lying.
Exactly.
Great. Thank you for clarifying that. I like that. So we're just about time. So I just want to make a quick plug again for our advocacy grassroots list. Again, if you want to join, please go to mda.org/advocacy, or you can text MDA USA to 50457. We'd love to have you on our grassroots list. And I want to at least take the time to thank our 3 experts on the panel. I think this was wonderful. I think there's some great advice given to folks about knowing their rights, their employer rights if they have a disability. So thank you both very much. Please stay tuned to our next Advocacy Institute session. And with that, we'll end it. So thank you all. We hope you enjoyed it, and we'll see you next time. Thank you very much.
Thank you.
Thank you.